if you're upside down, underwater, or even concerned that with prices going down, you might not sell your house for enough money to cover your realtor expenses and closing costs, you should be aware that the California Association of Realtors lawyers are really smart, and they did a great job. And they talk about your alternatives to a short sale, because short sale is not always going to be best. And then in the end here, they ask you to sign off on it, saying you understand and acknowledge that you've received a copy and you understand the terms. Because your realtors, like realtors, are going to approach you and say they can help you. They're a foreclosure alternative. They're going to counsel you on your options. Now, the Realtor Association is telling you they're not licensed to do that in paragraph 8. They're saying right here, a real estate broker cannot give legal or tax advice in connection with any of the options available to the borrower, nor can the broker suggest what is the best course of action for the owner. But I understand that some of you aren't aware that in a short sale, your attorney and your realtor could be paid by the bank. You don't have to pay the attorney up front if you're doing a short sale. At least you wouldn't with me, and I know other attorneys who've worked like that. We'll get paid out of the realtor fees or for doing the negotiation, and sometimes the banks even pay us more money. So, it's not a problem putting an attorney on your team. So your first question to every realtor when you're considering all your alternatives would be could you send me a copy of this? I'd like to read it. I'd like to read it for 2 or 3 days before you even come out to the property, because I know a lot of you realtors are trained in saying, I answer your client every question. If they're not ready to sign a listing agreement, find out why and go over it with them again and keep asking them questions until they're ready to list, right? That's realtor training. I don't see how they can go through that training and not be prepared to answer, well, maybe you should do a forbearance. Maybe you should be a loan mod. Why wouldn't you do a deed in lieu instead of a short sale? If a deed in lieu could protect your credit as part of the negotiations, if some banks like Chase, in certain circumstances, don't even make you turn over a roadmap to your assets or a hardship to get a deed in lieu done, like, why would you do a short sale? They're going to answer those questions, even though they're not supposed to. And that's okay. I'm not trying to sue realtors right now. I'm a broker and attorney. I'm just trying to say that's the first question. Read the short sale listing addendum, get your questions answered, but make sure those questions are answered in writing and signed by a realtor's broker. If they try to answer any questions like this, will you owe the bank money after a short sale? Will you owe the IRS or the Franchise Tax Board or the Franchise Tax Board taxes after a short sale? And what is a realtor remark that you're going to negotiate for on your credit? And why could you do better with an attorney? And if you ask those questions, you're starting. And if they answer, I'll be amazed. And so really the next question, after you get the short sale listing addendum and you review it, your very first question would be, will I owe the bank money after a short sale? And they're going to tell you, don't worry, 580E protects you. Well, it only protects some people if you fit within this framework, but many sellers do. But in this same thing, the California Association of Realtors wrote this: seller is encouraged to obtain written agreement from lenders or other applicable lien holders addressing whether and to what extent seller will be released from monetary or other claim obligation, and they're told to talk to an attorney. So if 580E protected you in a short sale, but the approval letter says they still aren't releasing you from the short sale, and they use language, and they sometimes don't even use proper language. I've seen many approval letters with the word mortgage. They're releasing the mortgage. Well, what's a mortgage in California? I haven't seen a mortgage in California in 15 years and over thousands of files. It's a deed in lieu and a promissory note. It's a lien and a note. It's a lien and a loan. It's not a mortgage. So I don't even know what that means. So like, you're going to want proper language. The lawyers at the California Association of Realtors, with their updated 625 agreement, are telling you, regardless of 580E, you need a proper language in your approval letter. And why would they write that? Well, it's because one of the reasons is we know about all these zombie loan problems. The second reason is, and this is what I was recently exploring with respect to taxes, the Mortgage Debt Forgiveness Act expired in 2025, and there's a breakdown between what happens after a short sale and what the tax courts found what happens after a foreclosure in California. And if you've got a recourse loan, it might be better for you to take a foreclosure over a short sale if you can't exclude that 1099 income. So let's say you're $100,000 short. And we know after a really negotiated short sale, the bank is going to send out a notice, a 1099-C to you, and saying this is a cancellation of debt income of, let's say, $100,000 to you, and they send that notice to the bank. I mean, to the IRS. When the IRS sees that, they've got directives now, if you read and research, and I'm hoping it changes because it's brutal, but they've got directives saying that their agent should look at the difference in the original nature of the net and whether it was recourse or non-recourse. And if it's recourse, it's based on the fact that the Barber letterboxer was rescinded by the bank. I mean, if you really want to get technical, at first they said after 580E, we're going to view this as non-recourse. Then 2 years later, they said, oh, that was overbroad. And now they seem to be arguing that you would owe taxes after a short sale if you have recourse loans. Now, many of you are going to want to know other alternatives because there are, if you're worried about the taxes and you can't exclude that 1099 income, there are better alternatives than a short sale for averting taxes. So you're going to want to talk to an attorney. You're going to want to have an attorney on your team. And the final piece here is, well, if the approval letter is so important, are you going to pay to put an attorney on my team to review that approval letter to help us leverage the laws in California to get the results we want with respect to our credit, with respect to taxes, with respect to owing the bank for the deficiency after a short sale? Are you going to do that? So we have the approval letter and we start negotiating for what we want in that approval letter ahead of time if necessary. And so for me, given the fact that, let's say your house is $1 million at a short sale price, and your realtor is going to ask for 2.5% or 3% just for listing the property, not even the buyer agent commission, $25,000 or $30,000, and the bank pays that. And in short sales, basically every short sale approval letter I ever saw but one, the bank agreed to pay the realtor fees. And you could have an attorney broker like myself working with your local realtor, your favorite realtor, your brother, your sister. If you talk to us first, we can work together. I will get paid by the bank. So will your realtor. So it'd be no cost to you to have an attorney on your team to help you do the approval letter. Now, if your realtor can say, no, I don't want to work with an attorney, and I'll pay to have them review the approval letter, I'd say, okay. If you get all these other questions answered, okay, let's do that. That sounds like you're protecting me. But those are your options. I'd say, if you want to learn more, I'm going to go through every paragraph of this, and it's going to be super interesting in my free short sale guide, shortsaleguide.upsidedownrealestate.com. And it's a foreclosure guide too, because we're going to start off with the alternatives to the short sale. Well, we're not going to start. It'll be the second video, and A, B, and C, and D are going to be covered. Then we'll do the third video, so you can get all the information. And I know many of you eventually will be like, all right, I get it. I can see why it would be good to work with an attorney, get my plan. Maybe I don't even do a short sale right away. Maybe I protect my credit by doing a deed in lieu. But I want to know all these things. And I can still always do a short sale. So I'll talk to John or I'll talk to another attorney. So that's always going to be available. But right now, I'd say go learn more. I just know. I already know. I remember many, many people read everything before they made a decision. And I applaud that. So we're going to work off of this because it's so succinct and so clear. But in the end, some of you will want to talk to an attorney and some will want to talk to a real estate agent who will put an attorney on your team. Because I would say, even if you have purchase money loans, and we all know what purchase money loan, not all, but many of us know, even now, you're still going to want to negotiate for an appropriate approval letter that mirrors the law. Because there are obviously issues for the California Association of Realtors, lawyers to put that in there. My name is John McConnin, UpsideDownRealEstate.com. Get the free guide at ShortSaleGuide.com, and I will put this listing addendum in there for those of you who want to come up to speed before talking to me or any other realtor. Thanks. Talk to you later. Bye.